Good evening, ladies and gentlemen. Today I'm going to talk to you about the impact of the national law on the regulation of medical practice. The framework of medical practice is extremely complex in Australia, with many entities involved. This is compared to other countries such as the UK, which has twice the number of practitioners, and also in New Zealand, our closest neighbor, which only has a single entity that both accredits medical schools, postgraduate training, registration, and receives complaints. Some of the entities here are the Australian Medical Council, the Royal Colleges, the Office of the Health Ombudsman, Health Complaints Commission in New South Wales, the Medical Board of Australia, the APRA, employment law, and the federal government. The federal government controls where doctors can work through the Health Insurance Act, Section 19AA, Section 19AA creates a 10-year moratorium on access to Medicare benefits for foreign overseas trained doctors and foreign medical students, such that they can only work in districts of workforce shortage. While previously all these various health professions had separate boards on their own, all these were brought under the umbrella of APRA to create one single national registration scheme. The objectives of this national law was to protect the public and facilitate mobility of the health workforce, and it was run by the ministerial council of the various states. With the advent of APRA, the profession became professionally led rather than self-regulated. Queensland was chosen to enact the substantive legislation, which then was adopted by other states and territories. To start with, APRA had 14 national boards, but from the start, the law was not applied uniformly, with Queensland and New South Wales opting out of Part 8, which is the part that concerns health performance and conduct process, while Western Australia opted out of mandatory reporting. The responsible tribunal was CQULAT, and each state would adopt the national law in the schedule within an act. Of note is the Section 7, which excludes the Acts Interpretation Act, as the national law had its own interpretation section, and the Privacy Acts and Right to Information Acts for the Commonwealth were used. The complaint process in all states was directly to APRA, except for Queensland and New South Wales, where it went to a healthcare complaint entity. The process is extremely complicated and takes a very long time, but from the tribunal, there is an avenue of appeal to the Court of Appeal and thence to the High Court of Australia. The disciplinary process has two parts: performance and health. Where it concerns performance, a doctor may be accused of professional misconduct, unprofessional conduct, and unsatisfactory professional performance. With regards to health, mandatory and voluntary notifications can be made. What is the standard? The standard is made explicit in the Good Medical Practice Code created by the Australian Medical Council. However, the impact of complaints is very severe on medical practitioners. Although 80% resulted in no action being taken and only 1% to suspension or deregistration, more than 44% took over a year to settle. This caused an immense amount of stress on the practitioner, 90% of which results in defensive behavior. This kind of behavior increases the cost of medical care as well as results in unnecessary investigations and referrals. Some studies have shown that complaints are more likely for overseas trained doctors. I thought it would be interesting to see how the courts would interpret the national law. More than one judge has described it as a legislative maze. However, it's been held that APRA is a separate legal entity to its predecessor medical boards and was not able to collect on debts owed. There was also limited power of the courts to grant relief, as the national law was taken to be exhaustive, and that registration is solely the province of the medical board. However, APRA is held to need to accord natural justice, which would have been a ground for appeal. Professional misconduct and unprofessional conduct with regard to competency, ethics, and behavior damaging to the profession, and this can occur even outside the practice of medicine, such as sending 9,000 text messages to a former boyfriend or posting offensive messages in an overseas internet chat room, but not apparently running a euthanasia website. Sexual impropriety is another cause for discipline, even when not with patients, and certainly unorthodox treatment is held to create ethical issues. However, APRA itself has not been immune to criticism. It has been accused of denying natural justice and presumption of innocence. There has been cases of inadequate investigation before placing conditions, and also the fact that its staff have no medical knowledge or background. Decision makers are protected, and therefore their decisions lack accountability. There's lack of transparency and minimal oversight from the Ministerial Council. Also, this law and decisions have not been made uniformly across the various states, and there was no recourse against vexatious or even ridiculous complaints. A number of reviews have been held by the Senate, by an independent review, as well as the Victorian legislation. And hopefully these will lead to greater transparency and accountability. In conclusion, the national law and its creation, APRA, has achieved a uniform registration across Australia, increased the mobility of doctors, and transfer of information regarding registration. However, it still has many issues, primarily regarding the disciplinary process, accountability, and transparency. However, doctors need to embrace regulations that will preserve public safety, increase governance, and ensure quality of healthcare while maintaining the respect and stature of the profession. If they are unhappy with the process, they need to be more involved. As ever, this requires education and a change in mindset. Thank you.